We're going to discuss the public charge roadblock. We're going to discuss what is a public charge. We're going to discuss what this new public charge set of rules means for green card applicants. And we're going to discuss what immigrants who would like to become permanent residents need to prepare for in the future. So let's begin with the issue of what is a public charge. A public charge is basically someone who cannot support themselves, who cannot survive without long-term government assistance, without reliance on government assistance as a main source for their day-to-day living needs. It is what lawyers call a prospective test, meaning that it's a little speculative. It looks at what will become of the person seeking green card benefits at the time they're applying. It is not necessarily based on what will happen, but it's based on what the officer thinks will happen. And that's crucial to know, because in your preparation, you're going to have to know that the officer is looking at this issue and how to deal with it. We'll get to that in a moment. So who will be affected? Well, it's going to be all green card applicants. There are right now two different categories, so to speak, of individuals that fall subject to the new public charge rules. The first set are those already in place, and those are immigrants seeking to become permanent residents from abroad or seeking a visa to enter the United States. That went into effect in January. The rules went into effect in January. So those types of issues are already being raised in consular processing interviews. And there's been some reports of not so much good stuff happening, which indicates that for those that are going to be applying here, which is the second category, you need to get ready. And because the changes, although they're not in place yet, they're coming. If they've come to the consular processing offices, they're coming to the local USCIS offices very soon. So those who are seeking green cards locally in the United States at a local USCIS office are going to be affected. Those rules, as I said, are proposed. They are not necessarily in effect. And there are some exclusions to those seeking adjustment of status here in the United States, such as asylees and refugees, individuals seeking VAWA benefits or U visa benefits, some NACARA applicants, trafficking victims, and even children under the Special Immigrant Juvenile Act. Those are types of individuals seeking green card benefits that will not be affected by these new rules. So the rules or the parameters of the rules are new. The rule itself is not new. The rule has been in effect since 1882. The public charge issue has long been used to exclude individuals from entering the United States. So they're even in place now, and they were codified a little stronger in the mid-90s with the affidavit of support rules. Now when an individual applies for green card benefits, they have to have a financial sponsor who may or may not be the same person who's sponsoring them for the family-based visa. The financial sponsor then has to show that they have assets or resources or income that meets 125% of the federal poverty guidelines. Now that's, of course, if the immigrant themselves cannot qualify to show their income. But usually there's a sponsor, in some cases a co-sponsor. That co-sponsor and that sponsor speak to the issue of public charge. At present, it's only been a couple of issues that the government has really looked at. Now they're going to be looking at a lot more issues. At present, in 2016, only 3,237 individuals who applied for green card benefits were denied on public charge grounds. That's going to mushroom for reasons that I'm about to share. When the government officer looks at whether or not someone will be a public charge, they're required to look at the totality of that individual's situation as it affects their day-to-day living. They look at an immigrant's age, their health, their education, their income, their assets, their skills, their previous employment, their family status, how many people are in the family even, and similarly related relevant factors. And the only two items that have really been at issue until now were cash assistance and long-term care or institutionalization at government expense. The non-cash type of programs, such as health programs, nutrition programs, were not considered as public charge issues by government officers. That's about to change. Under the new rules, officers are going to consider whether immigrants, and not just immigrants, but any other family members, including their United States born children, have received various types of public benefits. Here's a short list of the benefits that they'll be taking a look at. SSI, Medicaid, WIC, Section 8, food stamps, low-cost energy assistance, even the earned income tax credit when people file tax returns, Head Start, children's health insurance, even people who took advantage of Obama healthcare coverage, and other types of subsidized government insurance programs. All of those are going to be looked at by immigration officers as they review permanent residency applications. And they're going to be looking at how long did a person receive it? How often did they receive it? Were they truthful about how long they were on the program, that they didn't exceed the time period that they should have been getting public benefits, or did they go on afterwards and not reveal a change in income or resources or assets? Those are types of issues that can get immigrant applicants into a lot of problems. One of the biggest issues that green card applicants will have to look at is whether or not they have received public benefits. This is a major, they even call it a major negative factor in the USCIS memo. Whether they've received public benefits for more than 6 months in the past 3 years. Now think about how that might occur. A female immigrant has a child about to be born, and they may have received 4 to 5 months of assistance while she was pregnant with that child. And perhaps that person had 2 children in the last 3 years that were born. Well, that's 10 months. That's over the 6-month threshold. That's going to be a problem. If people are currently receiving public benefits, well, that's a no-no. I mean, that's an issue that people should be very, 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 very careful with. And they need to make sure they check in with legal counsel if they're in that type of situation. Whether the individual has right now a costly or serious medical condition and they're going to need, or they are receiving some type of subsidized insurance, those are really heavy-duty negative factors that a government officer is going to look at. The memo notes a heavy heavy-duty positive factor that will help immigrants. And that's if they can show through their assets and income and resources that they can meet 250% of the federal poverty guideline standard. That's going to be difficult for most immigrants and mixed status families to meet. It would be hard for many American families to meet. So now the government officer is going to have the discretion to offer a public charge bond, that an individual applying for a green card can pay this bond. If I assume the way it's going to work, in their discretion, they're going to review things and say, well, this is really a good person, and they should be able to become a permanent resident. But I think they fall under the public charge guidelines. So I could deny their application, but I'm going to offer them a bond. The bond's going to be at least $10,000. And if an immigrant violates that, they're going to forfeit the entire bond. So think about that. The government looks at it and says, well, you look like you're going to fall under the public charge requirements, but I'm going to offer you a bond. And then that immigrant can get a $10,000 bond. Seems a little inconsistent. And it would also seem like the officer then is going to say, well, let me look into this. Is this a red flag here of something else? It could be a real problem. Opponents support this measure strongly. They say that it benefits taxpayers. And what I've read on the internet and I've heard on the news, that opponents of the amount of immigration we have coming into the country at present really feel that the United States is not just a country of immigrants, but a country of opportunity. And they believe that when immigrants come here, they should pull their own weight. They should be, as opponents like to say, makers, not takers. That they shouldn't use public benefits. They shouldn't deplete public funds that place a bigger burden on taxpayers. Politically, this is clearly another indication of the administration's wanting to slant immigration law away from immigrants coming from poorer countries. That's pretty clear. Opponents also argue that the expansion of public benefits from just the two former categories to the multiple forms now is that all public benefits are really cash benefits, even though it's not cash directly, it's cash indirectly because it comes out of government funds. What I think we're going to see in the next few months, especially as we lead up to elections and perhaps after the elections, is a return of the rhetoric that emerged during the Ronald Reagan years. Prior to Ronald Reagan, this country had went through a period of time after John Kennedy's election, when he declared a war on poverty, that poverty was more like something bad that had to be eradicated, that America was divided, those who have and those who don't have, and those who don't have should have, but we have to fight poverty. We have to fight causes, but we can do it because we're a very rich country. Well, Ronald Reagan flipped that argument on his head, and he looked at poor folks and he said that they were people that they were poor because they wanted to be poor. It was their own actions. And a lot of them were what he called cheaters, welfare cheaters. And he used this imagery of welfare bombers. For years, that was prevalent in American debate about assistance to poor people. And so poor people were suddenly looked at as something to be feared, not someone to be helped. And I think we're going to see a slight return on that issue, but we're going to see it return in the immigration context. That's where I think the debate is heading. And it's a very dangerous argument for immigrant supporters, because as they try to win the hearts of middle America, since middle America is the one picking up the tax burden, because as the American economy is squished, and as the middle class shrinks, more and more of these programs are paid for out of the government pocket, but it's through the taxes of the middle class. And so that argument is probably going to be transformed and twisted so that the middle class, those who sit on the fence between, I think immigrants should be helped, but I'm not so sure that I like immigration reform, are going to lean towards these types of rules and cut off immigration. They're going to buy into the argument that immigrants should make their own way, as it was for many, many years, because a lot of cases where people were struggling just simply wasn't reported. As I said, during the Reagan years, the whole issue of America, the poverty in America, wasn't a negative issue. And you'll recall, I mean, even in 1990, the census started counting folks that were homeless. So there's a real economic problem in America, and the middle class is the one feeling the effects of that. And that issue has been used by opponents of immigration reform, to fuel an anti-immigrant sentiment. So those individuals those activists and community leaders who support immigrants are going to have to be real careful on this issue. They're going to have to be real careful. They're going to need to strategically think how they're going to address such issues. So, some of the effects already occurring are that there are reports of mixed status families where there's an immigrant parent not who could seek benefits for one of their children who was a U.S. citizen, perhaps something like school lunches or some type of medical care program, staying away from that. Not because the citizen child isn't entitled to it. No, the law's not changing. They're entitled to it. What's changing is that the use of such resources will be used at an interview against the immigrant parent who seeks to become a permanent resident. So an immigrant parent who years later tries to become a permanent resident through their child because they were single, say it was a single mom, all of a sudden now the way that they survived and were able to raise that child to become a productive United States citizen, young adult, now has that thrown back in their face because they use government benefits. That's the type of issue where immigrants are going to have to reach out to the bar, to immigration lawyers, and say, wait a minute, I no longer can fill out this application alone. Yeah, they could, perhaps, maybe some, technically speaking, but developing the evidence and developing how to address those issues in advance are going to be critically important. And it's not something that folks could be risking, because then they're going to risk, losing the right to become a permanent resident. So in 2016, statistics show that there were 10.4 million U.S. citizen children with at least one immigrant parent in the same household. That's a lot. And of that amount, 56% of those households had received some kind of assistance like Medicaid or health insurance for the children or school lunches or similar items. 56%. These are households where individuals are not yet permanent residents. This is where the squeezing, this is where the tightening, this is where the reduction is going to take place. Now, I've been asked whether this rule will affect individuals applying for citizenship. Not directly, but very definitely indirectly. As in other types of citizenship cases nowadays, individuals are going and saying, hey, I want to apply for naturalization. I've been a citizen 5 years, 10 years, 20 years. And the government now is going back into old records. And because even in the permanent residency applications, there's been indications that a new form is being created for green card applications, so that these public charge issues can be directly looked at by the officers. So at the citizenship application, I could perceive in the future officers looking at someone saying, okay, so when you became a permanent resident, you noted that you had received public benefits. Yes. Well, let me take a look at that. And then the new applications, which aren't, the public charge information won't be in the applications, but they can go back and look at those records and say, well, there's inconsistent information here. That it appears that you may not have provided us accurate information 8 years ago when you got your green card. In that situation, the immigrant then is going to face a problem, not just of being denied naturalization, but perhaps being hit up with charges of misrepresentation years ago and charges of misrepresentation right now. So indirectly, naturalization applications could be affected. Can someone be deported when they're adjudicated as a public charge? Well, yes, but it's rare. There's two requirements that have to be in place. One is that someone has to become a public charge within 5 years of entering the United States. And those reasons that they became a public charge existed before they entered the United States. So let's consider how that happens. A United States citizen here wants to immigrate a spouse from another country or a child. And that spouse or child has a serious medical condition, cancer, leukemia. And that exists at the time the United States citizen petitions for their family member. But at the time that the family member petitions, they meet the required federal poverty guidelines. So it's not an issue. The person, it's not an issue. They're going to be able to take care of them. However, that immigrant then enters the United States and the condition worsens and the medical bills keeps getting higher and higher. Then what? All of a sudden, the citizen spouse doesn't have the income to support the medical needs of their spouse, and so they apply for public benefits. Then what? Is the spouse now in danger of being deported? Those are the types of issues, again, that immigrants are going to have to be real careful with. And immigrants, I strongly believe, are not going to be able to handle these types of issues on their own in most instances. They're going to need professional guidance. They're going to need professional assistance. And so this is something that I seriously would like everyone in that situation to consider. They need to plan ahead. If you've ever received any types of public benefits, you do need to talk to someone, and you need to talk to them now. Need to talk to someone such as a professional expert, not just anybody. And you need to get the type of counseling, professional counseling you need so that you can prepare for these issues down the line when you finally apply for green card benefits. It doesn't mean that it can't be done. It just means you're going to have to be super careful. I wish you and your family the best of luck going forward. I hope I haven't scared you. I hope that instead I've alerted you to what you need to do to survive in the future if you've ever received public benefits. You don't want to be labeled a public charge. You don't want to lose your green card case. And think about it. If you were, just one last point here. If you were to, let's say you were to be denied permanent residency, what happens then? Okay. in previous weeks, I've discussed changes going on with USCIS and Immigration Court. And USCIS officers now, if they deny an application of an immigrant, will be able to serve that person with a notice to appear at Immigration Court to be deported. See, because they're going to know that individual is an undocumented immigrant without papers or an overstay. And so they're going to be able to refer him immediately to Immigration Court to start immigration proceedings against him. And even though when you get the immigration proceedings, the U.S. spouse or child or whatever is going to try to revitalize the permanent residency application, or the immigrant will be able to perhaps seek other types of immigration relief. The Immigration Court also has new rules that they're not going to give you much time to get ready, because the new rule on continuances and then the new rule on administrative closure. So all this is tightening up the noose around the necks of immigrants seeking permanent residency in the future. It all comes together because the idea is to narrow the amount of those applicants who can succeed. And so I really, really hope that you don't find yourself in such a situation. And I do hope and you take to heart that going forward with all these new rules coming into place, that you seek professional guidance. And with that, have a great evening. I'll talk to you soon. Thanks for watching. Know someone who might be interested in this video? Then please take a moment to like and share it with them. Also, if you would like more videos on immigration, just click on the subscribe button. And here's a little bonus, a short guide that you can download for free by clicking on the link on the description box or the square-shaped image. Plus, if you have ideas for videos you'd like to see, write a short comment below, or feel free to contact me at carlos@VitaraImmigrationLaw.com. My name is Carlos Vitara. I appreciate your time, and hopefully we'll be talking again very, very soon.